The European Union's General Data Protection Regulation, GDPR, comes into force on 25th of May 2018. What does your organisation need to do to comply with the new law? In this session, we discuss the appointment, role and responsibilities of the Data Protection Officer, or DPO. When must you appoint a DPO? Article 37(1) of the GDPR requires the designation of a DPO in 3 specific cases: where the processing is carried out by a public authority or body, where the core activities of the controller or the processor consist of processing operations which require regular and systematic monitoring of data subjects on a large scale, or where the core activities of the controller or the processor consist of processing on a large scale of special categories of data, or personal data relating to criminal convictions and offences. Special categories of data in this context are those defined by Article 9 of the GDPR, and they include data concerning, for example, health, religious beliefs, philosophical beliefs, trade union membership. While the GDPR specifies circumstances in which a DPO must be appointed, any organisation is able on a voluntary basis to appoint a DPO. And it may be a very good idea to do so, because regardless of whether the GDPR obliges you to appoint a DPO, you must ensure that your organisation has sufficient staff and skills to discharge your obligations under the GDPR. Should you consider appointing a DPO and decide not to, then best practice is to record the reasons for that decision, in case you have to revisit it and discuss it with the regulator, the Information Commissioner's Office or ICO, at any stage. The DPO's minimum tasks are defined in Article 39. They are to inform and advise the organisation and its employees about their obligations to comply with the GDPR and other data protection laws. The DPO must monitor compliance with the GDPR and other data protection laws, including managing internal data protection activities, advising on data protection impact assessments, training staff and conducting internal audits. The DPO must also be the first point of contact for supervisory authorities and for individuals whose data is processed, who may be employees, customers or any other third-party data subject. Data Privacy Impact Assessments, or DPIAs, provide a good illustration of the Data Protection Officer's role in practice, and also of the relationship between the controller or processor and the DPO. The controller or processor should seek the DPO's advice on questions such as whether to carry out a data privacy impact assessment, what methodology to follow when carrying out a DPIA, what technical and organisational measures to apply to mitigate any risks to data subjects' rights that are disclosed by the DPIA, and whether the DPIA has been correctly carried out and meets the requirements of the GDPR. The GDPR requires that a DPO must have sufficient professional experience and expert knowledge of data protection law. At minimum, that involves a detailed knowledge of the GDPR itself, but depending on the organisation, may also extend to other areas such as e-privacy regulations. The necessary level of expert knowledge should be determined according to the type of processing your organisation carries out, taking into consideration the level of protection the personal data requires. For example, if it is or includes a high proportion of special category data, then the level of detailed expert knowledge required of your DPO may be higher. The DPO must report to the highest management level of your organisation, that is, to the board, and must be given adequate resources to carry out the DPO's duties and to ensure that the DPO remains up to date with legal developments and fully trained. The DPO operates independently and must not be dismissed or penalised for performing their task. The DPO may be a staff member of the controller or processor, or may fulfil the tasks on the basis of a service contract. That is, they can be an external appointment. The DPO may in fact be a team, as long as there is a designated lead contact and person in charge. Organisations can jointly appoint a DPO, provided that the DPO is easily accessible to each establishment, to each participant organisation, as a point of contact and advice. And crucially, the DPO must not hold a position that creates a conflict of interest, in particular, one that involves determining the purpose or means of processing personal data. Remember, the DPO's obligation is to inform and advise. It is not to decide. The DPO's role is crucial in ensuring that an organisation is equipped to comply with GDPR. However, the DPO is not personally responsible for non-compliance with the GDPR. That responsibility remains with the controller or processor. If you have any queries or would like to seek advice on any of the issues discussed in this webcast, please contact our data law team. Contact details are on the screen at the moment. Thank you for listening to this webcast. Please join us for our other sessions on data controllers, data processors, data privacy impact assessments, contractual issues for GDPR, and responding to personal data breaches.